Could switch on your mic, please.
Good afternoon, Chief Justice.
Are you well?
Under the circumstances, yes, Chief Justice, but a lot of butterflies, and I hope they will go away.
Okay, the butterflies was going to be my next question. You've been an attorney all your life, am I right?
That's correct, Chief Justice.
Is the total period 17 years or a little more than that?
It is a little more than that, Chief Justice. I got admitted in 1992,
Yes.
and I've been on the role of attorney since then. And yeah, it is definitely more than 17 years.
In that capacity, did you appear in the High Court or were you doing office work?
Well, I have appeared mostly in the magistrates' court, and to the extent at the time when we were in Polokwane, I used to instruct a lot of correspondents in Pretoria to do matters on my behalf. But when I moved to Johannesburg, I appeared in the High Court.
Yes. And for how long did you appear in the High Court? For
Well,
how many years?
I was with Norton Rose from 1997 until 1999, and then I moved into corporate, but I continued to appear together with lawyers that I was briefing in the High Court as part of the in-house lawyer.
By appearing in the High Court, do you mean arguing the case yourself or being in attendance, being present as advocate?
Being in attendance in person as part of the
Okay.
team that was appearing.
Okay. And what did you do as legal manager at IDC?
That job, Chief Justice, involves quite a lot. I head the litigation cluster within the legal department. We do all types of litigation, from commercial litigation. We do a lot of insolvency-related matters. We do business rescues. We do liquidation inquiries. We do very complex schemes of arrangement. I'm responsible for making sure that the papers that are put together are correct and acceptable before court.
How do you see the totality of your experience benefiting the bench, if at all it will?
That totality will be of benefit to the judiciary, Chief Justice, because with the benefit of hindsight, I am aware that probabilities are that if I had not switched to corporate and do the things that I did, that opportunity would not have been presented to me. So I feel that being part and parcel of the teams inside those companies that I've been involved in actually has equipped me well enough to be ready to do the job.
Now, what kind of advocates did you brief?
Well, we brief essentially black advocates as well as black law firms when we do the briefings.
I used to be a black advocate, but at the time very few black women advocates were briefed. Was there any sensitivity towards women as well?
Luckily not, but where I have been involved.
Luckily
in my case, I mean, where I've been involved, Chief Justice, I have tried to make sure that we brief even women, especially attorneys and conveyancers.
Yes. Oh, I didn't understand the luckily not part. Fortunately, you've clarified it. And have you had a problem with reserve judgments or not?
Reserve judgment, it's a problem generally, but in my case, I have tried as much as I can to really try and deliver judgments on time, except that there was one judgment where I did two combined matters, of which one judgment was delivered on time. The other one, I was only told later, where the parties had agreed that because the facts are all the same, they relate to this related parties. One judge ordered that actually they should be heard by one judgment, but by one judge. But other than that, I did not have any problem with reserve judgment. spreadsheet.
How long do you generally take to deliver a reserve?
Well, I've looked at my spreadsheet, Chief Justice, and you know they hover from it's from 1 month sometimes to about 3 months in the main. And part of the reason it's you know I just tend to be very cautious before I hand them down.
You're aware of some judges, even permanent, who take embarrassingly long to deliver their reserve judgments, are you not?
I have become aware of that, Chief Justice.
What do you think is the challenge? Why can't they do what you do?
I
What
think
is the problem?
the challenge there, Chief Justice, is that we just need to be focused on what we do. Personally, I don't sleep. When I have a reserve judgment, I get so concerned about it. I get so concerned because my issue is we owe it to the parties that appear before us. It's a constitutional mandate that we must discharge, and we must do it diligently and on time. So I think it's a matter of diligence. We all need to be diligent and make sure that they get delivered on time.
Yes. JP?
Thank you, Chief Justice. I think at the outset, Chief Justice, I need to declare that I know the candidate. We were at varsity together. One day he chased me out of his room when I laughed at him because he couldn't do Latin. We've kept in touch, so I know the candidate. Mr. Senyatsi,
Yes,
I
JP.
just want to go back to the reserve judgment issue you mentioned, because I want you to give a proper explanation or to clarify the issue there. That's the judgment in number 38 of your list, is that correct?
That is correct, JP.
Now, you say the other judgment you were alerted to it. What do you mean? Because I understood you to be saying these were two matters that were combined into one, which required one judgment.
Yes.
Can you clarify your answer, please?
This matter, as I said, related to the same parties. Facts were all the same. And parties appearing before me through their counsels agreed that the one judgment in respect of the one will be exactly the same in respect of the other. So when I delivered the first judgment, I think that is regarding Mukwena, which was delivered sometimes in December 2017. For some reason, the file of Dave's delivery was not with me, and I made a mistake of not just putting the case number regarding Dave's delivery and making sure that the same judgment was delivered. So I was only alerted by the attorneys sometimes this year. I think it was around July or August that, oh, by the way, Judge, we still having this judgment that is part of the Mukwena judgment that ought to have been delivered. But in fact, the delivery would have been exactly the same. It would have been the same in December 2017.
So, if I understood you well, what judges do is they would put the names of all the parties and reflect the case numbers of all those case numbers, the cases that have been joined together, and hand down one judgment.
Absolutely, JP. That's what should happen, and this is what I missed out.
Thank you very much. Let's just go to your spreadsheet. You've done 6 weeks in the opposed motion court. How did you find coming to the bench from the sidebar as you were and mostly as an in-house lawyer?
Initially, it was a bit challenging. I must say that the only experience I had in terms of writing anything remotely related to a judgment was the disciplinary inquiries that I often chaired. But it was challenging. But with the support of colleagues that I had, I soon started running with it. It was a learning curve, but I eventually get to understand what needed to be done.
Yeah. Let me just go back to your experience, especially as an in-house lawyer. What sort of legal work did you do at NAMPEC?
NAMPEC was a very interesting publicly listed company which specializes in packaging of materials being food, chemicals and so forth. So I did a lot of commercial litigation. I did intellectual properties in terms of registration of patents and prosecution of violations thereof. I also did trademarks and designs. So that opportunity actually assisted me in understanding exactly how the intellectual property law actually functioned, because we worked with local lawyers together with lawyers all over the continent as well as overseas.
And then at the South African Airways?
South African Airways, when I went there, I had very little experience in aviation law, but my stay there opened my new avenues into aviation law, in the sense that not only did we deal with bilateral air services, which are like state to state, but we also dealt with a lot of litigation as well as competition law related matters. South African Airways, especially cargo, of which I was stationed at, dealt with a lot of complaints against it from other airlines, and we were held before the Competition Commission or Tribunal now and again, and I was responsible on the cargo side of putting the papers together in defense of SAA. But not only that, I mean, SAA as an airline was also charged at one time by the American antitrust regulators. I was very responsible in working with the American lawyers, putting all the papers together. And even after I had left, they still visited me, and we put all the documents together, and we successfully defended those charges. So that experience actually helped me quite a lot, and I feel that it can stand in quite well for me on the bench.
And then at the IDC, that's where you dealt with a lot with liquidations and business rescues and schemes of arrangements.
Correct, JP.
Right. Now, what do you say to the criticism against you by the bar that you do not have enough exposure as a lawyer in private practice?
Well, that criticism would be valid if I was not practicing law at corporate level. But I have been always practicing law at corporate level. I have never done anything else other than practicing law at all the companies that I've worked for. I have never lost touch with the law. I've always been part and parcel of the law. I was actually never lost to the legal fraternity.
I see that in the second term of 2018, you did 6 weeks of criminal trial work.
Yes, I did, JP.
And how did you find that?
It was very good, because criminal work, it's where I actually started. That was the foundation of my practice when I started as a lawyer. And initially I was a bit intimidated, but again with the support of colleagues, I was reminded that as a lawyer, you know, you'd always be there. You'd always be able to grasp the issues. I'm glad to say that the stint that I spent at that court was of such a nature that I was able to at least finalize one big matter within a week, and the other one was a part head. It's still going to continue the beginning of the new term. But it was a good experience.
Thank you, Chief Justice.
Thank you, JP. MEC Lesufi.
Thank you so much, CJ. I think I'm covered. Thank you so much.
Thank you, Minister.
Thank you, Chief Justice. I'm particularly interested in your experience in the area of intellectual property law, with a specific focus on the recognition and protection of indigenous knowledge systems. To what extent would you say that South African law as it stands is poised to ensure that indigenous communities have full benefit and do not continue to incur exploitation without reward of their own indigenous knowledge systems, be it in the arts, be it in science and medicine, and various other areas of human endeavor.
Thank you, Mr. Minister. I actually think that's a very important area of the law that I think policy needs to be developed there, because as matters stand now, our community, with all the indigenous knowledge that they have not organized themselves so well to be able to pursue registration of their knowledge through the regulatory system. I believe a policy should be created in terms of which that knowledge can be protected, and that policy can only be created from the regulatory point of view with the intervention of the state. I will give you an example of where I come from. There are people with knowledge. They are called the Mohololas. They have knowledge of a particular herb that they use to cure the broken bones. That knowledge, it's lying somewhere. Nobody knows the true secrets of it. But I believe that it is something that from the policy point of view can be looked at, in terms of which people like that can be assisted to get a knowledge like that properly patented.
And just in terms of North and South issues, just on the same subject, do you believe that at an international law level, be it WTO level, etc., that sufficient systems are in place to safeguard the expatriation and exploitation of knowledge systems of indigenous communities in the developing world?
I do not think that at international law there is that protection. In fact, my view is that there's a lot of, the more international experts or companies who are involved either in medicine or any other avenue that can be economically exploited, I am of the view that they take advantage of indigenous knowledge and convert it into commercial benefit for themselves. And I feel that perhaps state to state, when the state meet to deal with these issues, these are some of the things that they should be looked at to try and protect that indigenous knowledge globally. Because at the moment, it is not organized, Mr. Minister.
And flowing from the two questions, my last question then becomes, do you see in the interim, whilst our law needs to be further developed, at least through legislation, in the interim, do you see much room for the judiciary to play any role in ensuring that to some extent the rights of indigenous people to the exploitation and benefit of their indigenous knowledge systems are protected? Do you see real possibility for the judiciary?
Real possibility, Mr. Minister, would start, in my view, from organizing communities, having workshops nationally, getting to understand at local level what information and knowledge is there and what it is that can be done. But I think this is something that would require to be driven more by government from the regulatory point of view, so that once that data is put together, then measures can be put in place to actually protect that knowledge.
Thank you, Chief Justice.
Thank you, Minister. Commissioner Schmidt? Oh, yes, follow up.
Thank you, Chief Justice.
Commissioner Didiza wants to follow up. Please bear
Sure.
with us. I'm sorry.
Thank you very much. It's just a follow-up. I hear you talking about the need for government to create policy, legislation, and community, maybe improve legislation because it's there, but also mobilization of communities. One of the things I would ask you, I'm not sure whether you might have been following the case with regards to South African agricultural industry and the European Union on issues of geographic indications. where, and this is not what you call the traditional communities, where the European parties, particularly different states, felt that South African agricultural industry can't use certain names which they have used for a number of years, such as champagne, grappa, ouzo. How would you say, from where you sit and the work that you have been doing in commercial law, some of those issues, particularly on trade matters, states can protect themselves from arbitrary? Because from a lay person's point of view, I thought it was arbitrary in the manner in which it was used.
Thank you, Commissioner Didiza. My view is simply this, that if the use of any name or trademark has been in existence long before anybody else could start, I mean, like champagne. Champagne, I think it's just a word that is acceptable related to wine. But I do not think that there is any country in the world that is actually entitled to the use of that word champagne. And as far as I'm concerned, in our law, if that invention is not new, there should not be any protection accorded to it. My view, South African organized agriculture is correct to resist the protection of the use of that name because it's not new.
Sadly, they lost it because they used it in reference to a location. That's why it was called geographic indication, because it's associated with a region in France which is called Champagne. I'm
not even sure that is, I hear you, Ms. Commissioner, but I'm not sure if that is, if you ask me, and I'm a layman when it comes to wines, but champagne, I took it to be just a wine, a particular kind of a wine. That's at least my understanding.
Commissioner Schmidt.
Thank you, Chief Justice. Mr. Senyatsi, you indicated that you were an ANC member from 1999 to 2012. Did you occupy any office within the ANC, or did you hold any public office?
I did not occupy any office within the ANC. I was just a member.
And no public office?
No public office.
Thank you, Mr. Chief Justice.
Commissioner Kane.
Thank you, Chief Justice. Good afternoon.
Good afternoon, Commissioner Kay.
You've been employed, I understand, in an executive capacity in two state-owned enterprises, the SAA and the IDC. What is going to be your approach when a review application is brought against either of those two institutions and you sitting on the bench?
Well, first of all, if I was never personally involved in the matter myself, I do not see any reason why I should not be able to deal with it. But to the extent that the matter may involve some of the agreements that I may have signed, I would definitely recuse myself, Ms. Commissioner.
Thank you. And one more question. What would your approach be in relation to disclosure of the record of the decision in the possession of a state-owned enterprise?
That is regulated by law, and to the extent that the law requires any state enterprise to disclose any information to any interested party, that information should be disclosed.
Thank you, CJ.
Thank you so much, Commissioner Kane. Commissioner Nkosi Thomas.
Good afternoon, Mr. Senyatsi. Thank you, Chief Justice.
Good afternoon, Commissioner Nkosi Thomas.
One is duty-bound to bring this comment to your attention, which is contained in the report provided to us by the GCB, paragraph 16.1. It's page, do you have it?
Page?
Page 83. There is, okay, perhaps I should do this. This is book 1 of 1.
Yes, I have page 83.
Of the GCB report.
And then it's paragraph?
16.1. see that? Book 1 of 1, para
Or book one,
of
I've got
1.
book 1 of 2, book 1 of 1, yes.
That's right. And there is a divider there, which is marked GCB. Mine is, has a
Yes.
a green face to it.
And that's page?
Page 83, paragraph 16.1. It's a comment that I consider to be adverse, but let's just help each other.
Yes, yes, yes.
They say it reads that a review.
15.1.
16.
Yes, yes, I've seen that.
Thank you. So just so we all on the same page, it
Yes.
reads a review of the candidate's judgments discloses a paucity of references to the Constitution and constitutional principles. The candidate was not involved in community projects in his professional capacity. I'm concerned pretty much with the first 2 lines that are you able to explain? Is this first of all correct? And if so, why has there been such paucity in your referencing as regards
There
the
is one
Constitution?
There is one judgment, Commissioner Thomas, Nkosi Thomas, that I wrote involving a matter of constitution. And I think that case involved it was an NGO versus a Ekurhuleni municipality, where the issue was really whether or not the municipality that pledges to support a cause or sponsor an event, whether they could rely on the provisions of, I think it's section 217 of the Constitution for not paying, as well as section 116 of local government Public Finance Management Act. What happened in that case was that after giving that pledge, when it was time for the municipality to pay, after being prominently displayed in the promotion material, as a sponsor of the event, they then refused and said, well, we did not comply with the provisions of the Constitution. And my view was, when I referred to the Constitution in that case, was that that case, the section was neither procurement of service or purchase of goods. And I specifically made reference in that case, in passing, that what ought to happen is that there's a need for our legislature to review on how sponsorship should be dealt with. And in particular, I had in mind, although I didn't write about it, that the judgment of our the funeral of our founding father of this nation, actually, from the media report that we saw, there were a lot of issues around how the sponsorship of that funeral was actually dealt with. So my view is, yes, I may not have had an opportunity of actually dealing with a lot of constitutional issues, but when those issues did present themselves, I did actually refer to the Constitution. And my view is as and when I'm confronted with any matter dealing with the Constitution, I should be in a position to actually apply the Constitution.
You see, Mr. Senyatsi, the Constitution is the supreme law of the land, and when one has regard to your answer at page 15 of book 1, 2, okay, what is it? Book 1 of 2,
Yes.
which asks the question, what proportion of your work is in the sphere of constitutional law? You said the 8%. Now, the question that comes to the fore, certainly to me, is whether it can be said that you are adequately proficient in constitutional law and the principles that emerge therefrom to be elevated to the bench at this stage.
As I understood the question, it really related to the time when I was in private practice. And at the time when I was in private practice, that was given, the answer was given in the context of that. It was not given in the context of the bench work that I was doing now.
perhaps I didn't make myself clear. The question is, are you confident that you are adequately
I am confident that I'm adequately equipped and ready to deal with and apply the Constitution.
Thank you.
Commissioner Norman?
Thank you, Chief Justice. Good afternoon, Mr.
Good
Senyatsi.
afternoon, Commissioner Norman.
Yes, thank you. Just as a follow-up to the question that Commissioner Nkosi Thomas had put to you, it relates to paragraph 16.1 of the GCB comment. They say the last sentence, she dealt with the first part of it, but the last sentence says the candidate was not involved in community projects in his professional capacity. But then may I also refer you to what you have stated in your application, book 1 of 2, paragraph 7 of that questionnaire, which is your questionnaire. It would be page 17.
Yes.
Or could you just read the last sentence, in fact, all of that paragraph?
I was a part-time lecturer for 6 years from 1990 to 1995 at University of Limpopo. I gave lectures in mercantile law, company law. I offered 1.5 lectures twice a week on Tuesdays and Thursdays evening. This was for me a way of giving back to the community of students and my contribution to the field of law, and I believe that I made a success of it.
Yes. So would that comment that you have not contributed to community projects in your professional capacity, would that be correct then?
It's not correct.
Thank you. Thank you, Chief Justice.
Thank you, Commissioner Norman. Your excuse, sir.
Thank you.
Sorry.
Thank you.
Oh, you want more?